Good evening, Masako-san, Buyuli, Sang-yun, Fumiaki. Thank you all for joining me today. This morning here, I'm at Oxford. It's still morning time, but I know it's already quite in the evening. So I appreciate you making the time to join, and also those who will join later on. So the title of my presentation is Navigating the Future of Indonesia's Competition Law in the Digital Era. So there's a funny or quite a curious, I wanted to start off with a curious headline um, by The Guardian, actually. This was in 2016, so almost 10 years ago. And they had this very interesting article that talks about the biggest invisible thing on Earth. Uh, and what they were referring to is Indonesia, right? And so I think, this kinds of summarizes a little bit, now that I'm here at Oxford and having been interacted with the international community, obviously members of not just Ascola Asia, but also the wider global Ascola community, um, I feel that there's still so much that the world doesn't know about Indonesia. And so I believe that this is part of my mission, I guess, as an academic, to kind of really try to be one of the voices. Of course, Buyuli has preceded me and has done an incredible job. So I hope to follow her footsteps as well, into trying to kind of shed light on some of the developments that's happening in Indonesia. And I have a very important reason, especially in the context of the digital economy, why other countries, um, should be paying attention, actually, even to the developments of Indonesia, and why they should care about the regulatory landscape, especially when it relates to the Indonesia's digital economy. One of the reasons why this is so is because in the ASEAN region, in Southeast Asia, Indonesia currently has the largest digital economy by, its gross market valuation, its GMV. So in terms of, um, the absolute amount, in 2025, it's already now 109 billion. So you can see this is almost three times many other jurisdictions in ASEAN, including Malaysia, um, Singapore, even. Obviously because of the number of population we have right now, I think 275 million or maybe 280 by this year. And so that huge consumer class within the uh, country is driving a lot of the growth, and it's going to be predicted to reach between 210 to 360 billion in 2030, which would be among one of the largest, probably top five in the world. And so, these big companies like Google, Facebook, I mean, Meta, um, are also now paying close attention to the regulatory landscape. And as we shall see, they're also now subjected to increasing scrutiny in Indonesia. And so when we look at the enforcement trends of the Indonesian Competition Authority, we see quite a positive development, which is that we see that the Indonesian Competition Authority is quite is following, we could say, some of the global trends on its focus in the digital economy. So with especially after the new competition authority, the new head of the KPPU, was sworn into office, he immediately stated that one of the key priority areas which he will focus on is in the digital economy. And we see that this is following the trends of major jurisdictions, such as the EU, obviously, even our neighbors like Australia and Singapore, other developing countries like Brazil, obviously other big players in the region like Japan and Korea, um, have also already kind of started this trend, probably a few years ahead of Indonesia. And true to his word, actually, there have been many interesting developments, both in the regulatory aspect as well as in the enforcement in the cases. And so the structure of my presentation today will focus on two key questions. The first one is, what are some of the key regulatory developments and landmark antitrust cases in Indonesia related to the digital economy? And obviously, I won't just describe what these developments are. I guess for some of the international audiences present today, this might present some new information, but I know Bu Yuli is here and she's probably already aware of these developments before me. So I would also provide some of my analysis and thoughts and reflections on some of these developments, especially when we benchmark these against the developments that have been occurring in major developed jurisdictions as well as other developing countries. Because my doctoral research currently is focusing on developing countries. And so I can have a comparative perspective with what's happening in Brazil and Mexico and all these other South Africa and other jurisdictions. The second question then, after reflecting on some of these key developments and perhaps some of the shortcomings or some of the reflections that I have, then I will elaborate, on what are some of the policy reforms that are necessary to ensure that Indonesia's competition policy can adequately safeguard competition in the digital economy. Um, so, okay, let's start. So let's begin now with mm, the first question on the recent developments and landmark cases in Indonesia's digital economy. So, in terms of regulatory developments, almost all of the developments, or actually all of the developments, have occurred not through legislative changes, but more through soft law and guidelines, which were published by the KPPU. So, there are four critical ones that I wanted to highlight. Number one is KPPU Regulation Number 3, 2023. This is the revamped merger control regulation. The second one is KPPU Regulation Number 2 to 2023 about now there's the possibility for companies to have behavioral changes or commitments, as they call it in the EU. Number three is KPPU Chairman Regulation Number 4, 2022 on guidelines on assessing relevant market and market definition. And this is especially important for the digital economy because, as you know, there are one of the distinct characteristics of the digital economy is the existence of multi-sided platforms. And this has huge ramifications and implications for the market definition exercise. And so they've also accommodated this in the new regulation. So yeah, focusing on three main regulations. And unfortunately, I think to the best of my knowledge, none of these regulations are in English. So maybe Bu Yuli, we can help the KPPU to try and translate because I'm sure international researchers, like especially I know, Masako was doing research in Indonesia, and it might this is probably one of the problems and one of the reasons why Indonesia is the biggest invisible thing on earth when it comes to the competition regulation because all of them are in Indonesian except for law number 5 of 1999. That has been translated. There is an official or unofficial translation. But most of these other, we could say, derivative regulations or soft law are all in Indonesian. So, I think this needs to be remedied. And Yuli, I don't know, maybe we can talk to our friends at KPPU and help them translate this because obviously if the people translating are also not aware of the equivalent English translations, then that might create confusion as well. So I can understand why they might not yet have published an English version for this. But I think that's very important to do, not just actually for the academic community, but also for business community, right? If there are multinational corporations who need to know legal certainty, like what is actually being regulated in the new market definition, I think it would be important to have some kind of official translation for that. So in terms of let's talk about the first one, um, Regulation Number 3, 2023. So there's many interesting aspects about this regulation, because maybe if you know the way that merger regulation is structured in Indonesia is that Law Number 5 of 1999 does not actually contain the provisions which regulate the details of how merger control is going to be implemented in Indonesia. So actually, the article in Law Number 5 of 1999 that does talk about mergers is saying that um, okay, mergers that are anti-competitive shall be prohibited in Indonesia, but then the regulation will be regulated in subsequent government regulations, right, Bu Yuli? So actually, the law itself does not contain any very specific or detailed provisions on merger control. So the government has had to had it's you could say a patchwork approach because then they enacted a government regulation, but then obviously, as time goes on, there are certain key critical, we could say, developments, which may take a long time if it had to be amended through the government regulation or amending the Competition Act, because that requires significant political will. So the KPPU, and this is why, it's regulated. The developments are not in the act or the statute, but it's in the soft law because the KPPU cannot wait for the executive or for the parliament to enact because there have been several attempts in the past, as you know, in 2014 and 2016, but both of them have failed because of a lack of political will and some opposition by lobbying groups. And so, they have done a good work in trying to adapt with some of the important developments by enacting this regulation. And so, in the context of the digital economy, I think okay, so the most important or the most fascinating thing that I found in the new revamped merger control regulation, although it's not labeled as such, but actually this is targeting the problem that many, 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 many scholars around the world are writing about now, which is killer acquisitions, right? That's one of the new key areas that's being, we could say, vigorously discussed and debated, even in the US and the EU. And actually, Indonesia now already has a solution for that. And so, um, one of the key changes is that in the new regulation, they state that um, a merger is notifiable not only based on the turnover thresholds of the companies, so not just on how big the companies are, but also based on the transaction value, right? And so if the value of the transaction exceeds 5 trillion rupiah or 300 and 3.1 million USD, it's probably higher now that the currency has gone down, unfortunately. Then, for this if the transaction value meets this threshold, even if the turnover of the companies do not exceed the turnover threshold, meaning that the size of the company who are merging does not exceed the minimum turnover requirements, then this is still notifiable to KPPU. And so I can imagine, that some of the previous deals that are now, with hindsight, criticized, and a lot of scholars have kind of have said that these mergers should have been reviewed or should have been criticized. For instance, like the Facebook Instagram merger, right? At the time, the Facebook Instagram merger did not meet the turnover thresholds either in the US or in the EU, but it was a $1 billion merger transaction. Like it was at the time it was the largest merger transaction ever. And so, yeah, if EU or the US had this rule, then it would have this would have been caught in their jurisdictions. And now, obviously, exposed merger, actually, even now the Meta case that's going in the United States courts, that's being litigated by the Department of Justice, is actually about that, right? And they want to split up Facebook, I mean Meta and Instagram. Yeah, and so then another interesting provision is that they note in the new merger regulation that the notification obligations also applies to foreign mergers. And this is something that I want to point out, which maybe in other jurisdictions is not kind of too contentious, but in Indonesia, the what makes this development very interesting is actually because there is no provision on extraterritoriality in our law. So in law number the definition of undertakings in Indonesia's Competition Act actually applies only exclusively um, to those companies who are incorporated in Indonesia. But obviously, then you know, the competition authority realizes that this condition is untenable. And so through developments of some case law, like the VLCC case, it was concerning a Singaporean tanker. They were incorporating some doctrines like the, implementation doctrine and the FX doctrine in Indonesia's some of the judgments. And this was also kind of upheld by the courts. So yeah, but I think this is very, very interesting because yeah, now even when the companies are not necessarily incorporated to Indonesia, technically they will still have a notification obligation if one or both of the companies own assets or generate sales in Indonesia. So this closely aligns to the effects doctrine, the qualified effects doctrine that you have in the EU and in the US. So as long as, even if these companies are not incorporated, if these startup companies or tech companies are not incorporated in Indonesia, but they have some kind of effect, they generate sales or they have assets in Indonesia, and it's still notifiable to the KPPU. One final note about the Indonesia's merger regime, which is highly suboptimal. And this is one of my big criticisms and Bu Yuli's and all of the competition scholars community is that we have a post-merger notification system, right? And this is really undesirable because obviously this means that it's only once the merger or acquisition is final and binding that it's formally notifiable or the requirement or the obligation to notify is formally in effect. This is, I think, we are probably one of the last countries in the world, maybe the only one right now, who still has a post merger notification system. And we can, the downside to this is obvious, which is that if the merger is already final and binding, how likely is it that the competition authority will be able to impose structural remedies like divestment, right, or breaking up the companies? And this creates huge inefficiencies, obviously, because if the transaction is already finalized, then it would incur so much cost on the companies, right, to divest. If suddenly KPPU says, okay, break up the companies, that might actually do more harm than good, especially if there's already, layovers and all these things. So, yeah, I mean, that's one of the things that needs to be fixed. But unfortunately, the provision on the obligation for notification is in law number 5 of 1999. So KPPU cannot change this. They cannot change the system from post-merger notification to pre-merger notification by enacting a regulation because in terms of the hierarchy of the law, this is below the act, right? KPPU regulation is, secondary because it's an implementing regulation towards the act or the law itself, the statute. There you go. Enforcement problems due to post-merger systems still in effect. In Article 29 of Law Number 5 of 1999. So the only way we can fix the system is if we amend the law. But unfortunately, as I know, I think Bu Yuli may also be aware. It's now in the prolegnas. It's in the what is it? The national legislative priority. So the amendment of the competition law is now in the current Parliament's kind of priority agenda. But we'll see how that goes. I have a lot to say about the amendment as well, especially in the context of the digital economy. So I hope that I can have an opportunity to kind of voice my ideas, in the process. So moving on very quickly, I think most of you are aware about behavioral commitments. Before this wasn't the case. So this is kind of a new development where KPPU may accept a change of behavior commitment during an investigation. And so this allows the possibility to obtain certain fine reductions or avoid fines. And so, yeah, however, if the companies try to engage in behavioral commitments and the process fail, meaning, and this is what happened actually with the Google case, which I'll talk about in a few minutes. then they cannot take this option again. So at the later stage. But of course, there are certain exemptions for this. And so, cartel conducts like price fixing, market sharing, bid rigging, as well as, gun jumping, which is failure to file, cannot be settled through change of behavior commitments. And the logic behind this is because these are some of the most egregious, these are some of the most harmful anti-competitive conducts. So it's exempted from the behavioral commitments. But one of my, I guess, criticisms of this is that actually this could have been an opportunity to implement a leniency program, right? Because we know that one of the most effective tools that we've seen countries using, and I know Japan also has a leniency program, right? If correct me if I'm wrong. I think Japan also has a leniency program. Korea has a leniency program as well. And yeah, this is one of the most effective enforcement tools that countries and jurisdictions around the world have adopted in the past, I guess 5 decades or so, ever since the US started to implement theirs in the 50s, 60s. Um, because this enables the competition authority to gain the certain evidence, right, which would make their prosecution easier. And this is actually one of the core problems in Indonesia's enforcement, which is, economic evidence, indirect evidence, Bu Yuli, as you know, has been met with high skepticism in Indonesia, right? There's a lot of criticism against indirect evidence and economic evidence. But then at the same time, the KPPU doesn't have dawn rate authority, so they cannot go to the offices and get the evidence and the documents. And also at the same time, we have no leniency program. So it's like, so how is KPPU supposed to get the incriminating evidence, right? It's very difficult. Like, the KPPU has a very tough job um, in this regard. And actually, I did a bit of research a while back when I was at Harvard, and I found that um, the majority of cases in Indonesia that were overturned in the Supreme Court was due to insufficient evidence. So the Supreme Court is saying, oh, insufficient evidence, you didn't prove the burden of proof. And so it was reversed. You didn't have enough evidence. But yeah, if we don't have these tools, then how are they supposed to get the evidence, right? And so this could have been, I think, a missed opportunity. They could have also included a mechanism for in addition to the behavioral commitments and reducing the fines for those companies who engage in behavioral commitments. It could have also been an opportunity to include a mechanism for leniency. And then the last one, the one on market definition. So this is a quite one that is I would say one that is I would is very much appreciated from the KPPU. It shows that they are keeping abreast and up to date with the recent developments when it comes to the digital economy. Previously the tools that they had in some of the previous market definition regulations were still based on quite outdated tools, and they didn't recognize the existence of multi-sided markets and how you define multi-sided markets. And so, yeah, they have some now guidelines on how they will consider when there is multi-sided markets. They will consider the dynamics, how it affects one another, and yeah, what is the role of the intermediate of the platform in connecting these groups of users. One reflection that I have with this is, obviously this was still in 2022, but now that it's 2025, there are newer tools, let's say, that some of the courts in the EU have also recognized and that have been developed by the European Commission and some of the other, you could say, leading competition authorities, which are not yet in this regulation. So one of the difficulties in defining relevant market for digital economy is obviously the existence of zero price markets, right? And so if you were to try to use the SNP test to define, relevant market in a market where the services are priced at zero, well, how do you calculate 15% of zero? Like 15% of something that's free is still zero, right? So it's still technically like the intellectual exercise becomes a little bit moot. And so if you were just to simply follow the SNP test on and these kind of more traditional tools, then it wouldn't actually yield an optimal result. And so some of the new, more recent tools that was also recognized by the Court of Justice in the Google Shopping case and in the Google Android case is called the SSNDQ. the small but significant non-transitory decrease in quality. So they substitute the increase in price to another form of anti-competitive harm, which is decrease in quality. And then they hypothesize, right? If the quality of Google search engine is decreased by a significant degree, would they then switch to whatever, like Bing or Baidu or I don't know, these other obscure search engines, right? And then you can conduct the exercise until they no longer switch because they're no longer substitutable. And so this was not yet in the regulation, and I believe this is something that could have actually helped them a lot in the landmark cases, which is, the most recent one is the Google case. So, Masato, can I just ask how much time I have? I know we started a bit late, but I'm looking at my time, it's 10:35, so I wanted to just...
Anytime.
Continue.
Yeah, please continue. Yeah, anytime.
Okay. Okay. So the Google case is undoubtedly the biggest case Indonesia's competition authority has ever investigated and prosecuted, not just in terms of the fines that they issued, but also in terms of who they were investigating. And this presents in terms of my own research, as quite a hopeful case for other developing countries, because what I've observed in some other parts of the world is that there is a reluctance in going after the big tech players, because they are much more powerful, they have much more financial resources, they have literally an army of lawyers compared to the competition authority. There's huge information and power asymmetries between developing country authorities and the big tech companies like Google, Facebook, Amazon, and so on and so forth. And so I really appreciate the KPPU's efforts in this investigation, and that they had the courage to stand up to Google and kind of still charge ahead with this. So that's hopeful, and it gives quite a strong message to other developing countries and as other countries in the region. So the Indonesia's Google case, actually, I met with a Korean scholar in there was an Oxford symposium for Asian competition law. But this Korean scholar told me that, oh, this is basically inspired by the Korean Google case. So thank you, Korea, for yeah. But I mean, obviously the KPPU wouldn't kind of admit it, but I mean, but to be fair, also they do these conducts in many other countries, right? Not just Indonesia. So I think Korea and Netherlands was one of the first countries to investigate this case, and it was about the Google Pay billing. So what happened in this case is basically Google engaged in an abuse of dominant position in the App Store, and specifically the Google Pay billing kind of service in their App Store, where they engaged in what I call as a two-phase abuse of dominance. So there's both an exclusionary and an exploitative aspect. So on the first stage, Google actually in I think 2022 enacted a new policy informing all of the app developers in Indonesia that, of course, they use language like due to reasons of security, etc., etc. All of the app developers, if you want to be listed in the App Store, must from now on use exclusively the Google Pay billing system, right? Because they said, oh, we have to maintain the security and protecting the consumers, etc., and so on and so forth. So all of the in-app purchases of apps that are listed in the Google Play Store, they can only use Google Pay billing, and they cannot use B2B, arrangements. So what this did is this basically kind of eliminated alternative payment systems, the availability for both the app developers and consumers to have alternative payment systems for their in-app purchases. And this is also, by the way, only exclusively for digital goods. So it's only for those apps that are providing digital goods like games, right? Like certain educational platforms like Ruang Guru and so on and so forth. But those that don't provide digital services like Gojek and Tokopedia were not bound by the same rules. And I have a little bit of an insight that I mean, I know this is going to be recorded in YouTube, but it's fine. I mean, this information is public anyway. One of my theories and reflections why it was only targeted to digital goods is because Google is an investor in Gojek, right? And Tokopedia. So they have certain interest in some of these other companies that are providing non-digital goods. And so yeah. Meanwhile, some of these other companies and startups in Indonesia that provided digital goods, I think they were a little bit distant. Google did not have any commercial interest in them, and their commercial interests were actually um, served by implementing the second phase of the abuse, which is once the developers were locked into the Google payment billing system, then Google imposed a service fee of up to 30%, and this represented between 5 to 6 times increase, 5 to 6x increase. Before, when B2B kind of payment processes were still available, the service fee was between 3% to 6%, which is still normal. But suddenly, when they introduced Google Pay billing, then it was increased to 30%. So yeah, between 10 times to 6 times the increase, and obviously this crippled many of the startup because as you know, the margins for startups are extremely thin. So once they suddenly had this monopoly tax, as the Netherlands authorities call it, yeah, it's many of them were unable to financially stay afloat, right? Yeah, and so because of this, then the KPPU found that they abused, Article 25 of Law Number 5 of 1999, among others. And then they fined a record-breaking 202.5 billion rupiah against Google, which in dollar terms is actually peanuts for them because it represents $12 million. And I actually did write an article about this, but I'll talk about it at the end. The second and another landmark case, I'll quite quickly go through this, is the Shopee case. And so this is actually this is actually the first case, to my knowledge, that took advantage of the new regulation on behavioral commitments. So the Shopee case, in the Indonesian competition language, they engaged in discriminatory behavior. But if we compare this to some of the cases that are happening elsewhere, especially in Europe, this is actually falls very neatly to the new theory of harm called self-preferencing, right? So what happened in this case is that Shopee provided automatic defaults for its own courier services. So Shopee Express and JNT Expresses were automatically being activated whenever a user wanted to order, like any goods from Shopee. So basically, the default when you want to buy something from Shopee was that it would automatically be, their courier service. And obviously, this is almost exactly like, the Google Android case, and those theories of harm, where in the Google Android case, Google was held to abuse their dominant position by having the Google search engine as the default, pre-installed in all Android devices. And there was also another issue on, dual position of there are directors in Shopee who are also serving as directors in Shopee Express and other and JNT, which obviously created a conflict of interest. But then, yeah, in that case, they immediately complied with KPPU's request for change of behavior, and so this was settled outside of court and without a decision. Last one, which is quite an old case, but seems to me I'm hearing rumors that it's going to resurface on a bigger scale. We had a big ecosystem merger between Gojek and Tokopedia, right, a few years back, and this was before ecosystem theories of harm had been, you could say, is before it was kind of popular amongst the competition academic community. So yeah, Gojek, as you know, is the biggest ride-hailing service at the time in Indonesia. Tokopedia was the biggest or one of the biggest e-commerce platforms in Indonesia, and then they merged together to form Goto. And now the rumors that I'm hearing is that Grab is planning to acquire Goto. I don't know if Bu Yuli has, maybe if we stop the recording, if you have some inside information for me, but from what I'm hearing from friends and I'm just seeing some tidbits on the news, there are rumors that they're planning to have that acquisition, which would be massive. I mean, if Grab, it's basically a duopoly now, right? It's Grab and Goto. So if they merge, then it will be basically de facto monopoly. Plus, you have the Tokopedia ecosystem there as well. So this I'm sure this would be highly scrutinized by the KPP once it is once it actually becomes formal. But yeah, my reflections on this is that unfortunately, ecosystem theories of harm is not yet recognized, and I don't know but I'm sure KPPU is also keeping up to date with some of the developments. But this is something that if they do merge, uh, I guess it would be easier because Grab and Gojek are competitors, so it would be horizontal merger. But in the future, I think it would be important to incorporate some of the newer theories of harm, like ecosystem theories of harm. So in terms of policy reforms, this is largely based on some of my work at Oxford right now. And so there are three levels where I believe policy reform could be made. The first is the material, which is the substantive. Second layer then would be the procedural aspect. And then the final one would be the institutional aspect. In terms of material or the substantive aspect, as I mentioned, it is extremely important to include now novel theories of harm and novel methodologies because, obviously the way that, these startups' business models are vastly different than people selling oranges and apples in the market. The existence of big data and algorithms all necessitate a closer examination of the way that certain anti-competitive behavior could be conducted. And again, as I mentioned, there are some, you could say, characteristics which require a different approach and methodology, like the SSNDQ test in defining the market. So it would be very important to accommodate that. The second thing is to recognize that firms who, now in the digital economy, because there are certain sources of market power that enable firms to exercise substantial market power, even when they have their market shares below traditional sources, it's important to recognize that this is a possibility. In Indonesia, in Article 25, we still use a very outdated, rigid threshold of defining dominance as 50% plus, right? So the threshold is like in order for a dominant company to be dominant, you need to prove that they have a market share of above 50%. But then the problem is, even even in conventional economies, we've seen case laws where companies could actually exercise dominance even below 50%, especially when the rest of the playing field have market shares that are widely dispersed. So if you have one company that has 40%, and then you have 100 other companies with 0.1%, then it's clear, right? It's not even a question. And so that's very important, especially now that firms have big data, they can leverage some of the insights that they have. There are firms who act as gatekeepers, right, in the digital economy, even if in certain markets they're not yet, in a dominant position. They're slowly getting there, and they can leverage their market power from one market where they're already dominant to another market where they're not yet dominant. And so the third substantive policy reform that I suggest is to shift the focus away from single market, which is a very conventional approach, to looking at the ecosystem effects and looking at how different markets within the ecosystems interact, and to consider direct evidence of market power. In terms of procedure, obviously switch, like please, we need to switch from a pre-merger notification system. The second one is to consider, this is actually one of the reform proposals that's being discussed in the US at the moment, and some of the legislation, which is to shift the burden of proof for mergers when it's being conducted by dominant platforms. So obviously we know now the current burden is for the competition authority to demonstrate that the merger is harmful. But in view of some of these killer acquisitions that have taken place, there are reform proposals, especially in the US, and this Lina Khan was a champion of this, where she said that it should be the dominant companies who prove to demonstrate how the merger will not harm competition. So there is certain shifting in the burden of proof. And then the second one is to provide market investigation authorities. I think this is also really crucial, so that this enables the KPPU not just to look and investigate cases ex post when they've happened, but also ex ante, so they can to enable them to investigate the sector as a whole, and to be able to impose behavioral and structural remedies before the abuses or before the violations occur. Third is to lower certain market share thresholds and enable authorities to intervene earlier to prevent certain problems caused by tipping effects. Finally, increase capacity building. Obviously, this is something that all of competition authority around the world are doing. Um, yeah, and so because there's so much new developments and so many new um, characteristics and so much, you could say, like unconventional aspects in the digital economy. It is really, really critical that competition authorities are also up to date with these developments. Like, for instance, how does behavioral economics influence certain abusive conduct? Like we know in the Google Android cases was big. Like the literature that they used to say that defaults were harmful was actually literature from behavioral economics. The second suggestion would be to increase or to accommodate interagency cooperation, both procedurally and substantively, between relevant ministries and government institutions in Indonesia. Because we know that issues in digital economy is very multidisciplinary, right? And so KPPU themselves might not have experts in technology and in IT, right? But there are other ministries, like for instance, the Ministry of Digital Affairs, Komdigi, right? Who do probably have the technical expertise, and so um, having that alignment and having that synergy between them would increase the capacity of them to enforce on these more technical matters. And then the third one, if it's possible, obviously, like what the UK is doing, is add a dedicated unit that focuses on digital markets in the KPPU. But of course, this does require additional budgetary considerations. And so, yeah, if this is not possible in terms of budget, then the second option would be much more efficient. Future research agenda. This is something that I've written about as an op-ed, and I'm thinking of developing as a piece later on, is whether or not Indonesia actually needs its own Digital Markets Act, like how the EU has enacted its Digital Markets Act. And we know that there are several developing countries around the world, including Brazil, who are already contemplating certain bills in their parliaments that have a DMA type regulation, right? And so, yeah, this is one of the things that I'm thinking about, and one of the things that I hope to be able to publish in the near future. And if you're interested in reading, but I wanted to get the idea out there as quickly as possible. So if you wanted to read this article, this opinion, I'm also happy to share it after the event. Okay, thank you so much, and I look forward to the discussions.
No, 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 don't stop here. Please share the idea about DMA.
Okay.
No, please do.
Okay. You mean for the DMA, like the DMA?
Please, please.
Okay. So because I'm just looking at the time, Masako, like so I don't want to overstep. So okay, all right. I'm happy that you guys still want me to go on. So what's my idea for the DMA? The argument that I wrote in the opinion article is basically to say that the current approach in Indonesia's competition law is inadequate for the digital economy for many reasons, and that an ex post approach oftentimes will yield results that are too little, too late, right? Like the Google case. So I use the Google case to demonstrate how, yes, in Indonesia, this is celebrated as a big win, but actually, in the grand scheme of things, this doesn't actually help. Um, I mean, number one, this doesn't even cause any deterrent effect. So it doesn't cause any deterrence for Google, because the only sanction that they got that was significant was the fine, and 12 million is something that they earn in half a day, probably, like, or maybe a quarter of a day in a few hours. So it's really $12 million is nothing for Google. If you look at their revenue, annual revenue, a couple of 100 billion dollars a year. It's really nothing. But more importantly, is what we have to realize is that so long as there is not a final and binding decision, Google can continue to do this, right? And now it's being challenged in the competition. The competition authority's decision is challenged, right? It's being appealed. So and this takes time. So you can imagine, because I was also involved actually a little bit, um, I was involved in helping the KPPU actually form during the case building phase of this case, and this started in 2022, and I'm now about to finish my PhD. So it's been like 3 years uh, that there was a final, sorry, that that the KPPU came out with a decision, and now we don't know how many more years it's going to take until the Supreme Court issues a decision. Because obviously, if Google loses again in the High Court, sorry, in the Commercial Court, then they're going to appeal again in the Supreme Court. And that could take another 1 to 2 years. So then in total, it'll be 6 to 7 years. And between 2022 until 2026 or 2027 or 2028, they would have reaped like billions and billions of rupiah from that 30% service fee that they're charging. And God knows how many startups have been stifled because of this policy, right? Because they can, so long as that's the presumption in the law, right? There's a presumption of innocence. So long as there is no final and binding decision, the conduct is assumed to be legal. It's only after there is a final and binding decision that the decision will be held as illegal, right? And so if it's presumed as legal, they can just continue. The other problem is there is no injunction. In Indonesia's competition law, we don't recognize the existence of injunctions. That it doesn't exist. Not like in Germany, for instance. The competition authority cannot say that a company must be able. They don't have the authority to say that they can stop. They can have an injunction on a company to stop, to cease certain conducts before a final and binding decision is made. They can order them to stop, but that's only after the decision is final and binding. So, because of some of these problems, I argue that an ex-ante approach is really, really important for Indonesia's digital economy moving forwards. Especially since we have a very, very, very large consumer market, which is one of the, you could say, the leverage that we have as a country. We have one of the largest consumer markets in the world for the tech companies. But it's then at the same time, that's why it's very important to protect these consumers, right, from anti-competitive harm. We also have quite a vibrant startup community, one of the most vibrant in ASEAN. So it's also important to protect the competitive process and to prevent abuses to these other kind of up and coming startups. And so the idea that I had was that it has it's been 25 years since the competition law has been enacted. There have been multiple attempts to revise the law, but it has not been successful at all until today. One of them is because there are, again, business interests and lobby groups who push back against this. And many of them are the ones who fund the parliamentarians when they run for elections. And so obviously there's a little bit of conflict of interest there, but obviously maybe not all. And so my logic is perhaps it might be more feasible to enact a DMA type regulation because that focuses on only a very specific sector. It won't be the entire law. It won't be the entire, competition anti-monopoly law that's being amended, but it might be easier to introduce a new law that's very niche and specific. Where all these other business interests might not be affected. It would be mostly actually the big tech, and most of them are foreign companies, right? And so there might be kind of more, in terms of the socio-political angle, it might be more feasible to do that. And obviously, we cannot, I argue we cannot just simply copy and paste the DMA as we've done with the Data Protection Act. Maybe Bu Yuli is also aware how we've kind of almost copy and pasted the GDPR into the Undang-Undang Pelindungan Data Pribadi, the Data Protection Act in Indonesia. I would say 80% of it was kind of just transplanted from the GDPR. But we cannot use that same approach for the DMA, not least because the economic realities, challenges in terms of the objectives of socioeconomic development is very different. There is no single market imperative, for instance, in Indonesia, right? And so on. I mean, yeah, and so on and so forth. So we need to consider enacting a DMA type regulation with certain thresholds, but we need to ensure that it is actually adapted to the needs of the Indonesian community, especially, for instance, if we consider the large consumer market and also the importance of small, medium enterprises, SMEs. This is not something that's considered in the DMA, right? They don't really think about small SMEs. But I think if we were to enact a similar thing, then I think it would be important to have those considerations being reflected in the law.